Thank you for checking out S&U's Contract Bank. I'm Roxanne Smithers, co-founder of Smithers and Ume Wabo, your trusted 360 general counsel. And so this video is going to address the Master Graphic Design Services Agreement. And again, this title is pretty self-explanatory. This contract is drafted and curated specifically with graphic designers in mind. And so we'll take a quick look through this agreement. Now, because this is a master agreement, you can not only utilize it with multiple customers and clients, but if you have recurring business with a specific customer or client, you can sign this master services agreement one time, utilize your services schedule to detail the specifics for any project, and never have to worry about negotiating your contract terms over and over again with your client. So let's take a look through this agreement. You are going to have one of the most important sections of this agreement in paragraph 2, which are your fees and expenses. This provision obviously lays out how you're going to be paid and whether or not you're reimbursed for any expenses that you have to incur as you're providing services to your client. There may be additional vendors, there may be additional software or equipment that may be required for you to provide the services. And if you and your customer have negotiated that they will reimburse you for those costs, that's addressed in this paragraph. Next, paragraph 3 covers how do the parties make modifications or changes to this agreement. If the parties decide down the road that they want to change some of the provisions in the agreement, this paragraph details how that happens. Most importantly, any changes should be handled in writing, and we encourage you to use that services schedule to update the scope of work or any specific changes that you want to make to a project. Paragraph 4 details your responsibilities as the designer and how you will utilize client input on your deliverables. It also lays out a time for the client to provide that input before you finalize deliverables. Paragraph 5 in turn details the responsibilities of your client. As many in the service industry know, that the timing of your work as well as the success of your services often depends on the quality as well as the timeliness of information, feedback, and approvals from your client. Paragraph 6 in the same vein discusses the delivery of your deliverables as well as a timeline for your client to accept those deliverables or to make changes to those deliverables. Paragraph 7 details intellectual property. This provision outlines what happens in terms of ownership of any of the items that you create as part of your services, as well as any intellectual property that your client brings to the table for you to utilize as part of your graphic design services. A very unique feature that gives creatives a bit of leverage is to maintain ownership of the intellectual property until final payment is made. Paragraph 8 details any representations that you are making with regards to the quality of the services you're providing and any promises or disclaimers regarding the results of your work. Paragraph 9 details that both parties agree to keep any information that they receive confidential in the process of working together and to not make that information public at all without the approval of the party who provided the information. Paragraph 10 lays out not only the duration of this agreement, i.e. the term, but also lays out how the parties can terminate either the agreement overall or terminate a specific project or schedule of services. It also details what happens in light of ownership of intellectual property as well as payment for services rendered. Paragraph 11 is for limitations of liability. This paragraph in sum puts a cap on either the type of damages or the amounts that you could be responsible for to your client if there are any losses or damages that are incurred because of your work. Paragraph 12 covers indemnification. In essence, indemnification says that a party that has been in the wrong or breached the contract in any way will be responsible for damages or losses that are incurred by the other party. In this provision, you are each agreeing to mutually indemnify each other. But of course, with paragraph 11, we've put a cap on the types of damages you'll be responsible for and or the amount that you will be responsible for. Paragraph 13 and 14 make it very clear that both you and your customer are free to provide services to and obtain services from other individuals. You are not working exclusively with each other. It also details that you are not an employee of your customer. Paragraph 15 details the state law that will govern this contract. Whatever state that you are located in, for example, Georgia, and you are running your business in the state, that state's law will govern this contract. Paragraph 16 handles disputes. What happens if the parties are not in agreement on their performance, their rights, or their obligations under this contract? Paragraph 6 covers that, requires the parties to try to negotiate, then to escalate to mediation, and then to escalate to arbitration if they're not able to come to terms. The parties can, of course, agree to a different dispute resolution process if they would like. The paragraph also states that whichever party is successful in pursuing a claim in the dispute resolution process will have the opportunity to have their legal expenses and costs reimbursed. Paragraph 17 covers how the parties are supposed to provide notice to each other as they are working in the project. Generally, we recommend notice is in writing and that communications are in writing. Paragraphs 18 and 19 cover how the contract will be interpreted by either a judge or an arbiter if you're in a dispute. And paragraph 19 states that if the arbitrator or the judge decides that any one provision of the contract is not enforceable, that the remainder of the contract will still be enforceable between the parties. And finally, paragraph 20 details that any outside communications or negotiations that are not contained in this agreement are then not part of the agreement between the parties. So you want to make sure that everything that you and your customer agree to in terms of your scope of services, timeline of services, expected results, and payment are detailed in this agreement. Then, of course, you will have your services schedule that you can utilize multiple copies of this to detail the scope of services for each individual project for your client. It details the description of those services, the types of deliverables that can be expected, the time frame for your performance, how you will be paid for your performance, if you want to have a payment schedule, if you want to have a retainer, any anticipated expenses that the client is going to be responsible for, as well as your rate if you are asked to provide services that are outside the scope of this original agreement. So we hope that this is a helpful overview of the event planning agreement. Of course, if at any time you'd like to discuss this contract or other issues with your business further, you can always schedule a consultation with one of the attorneys at Smithers and Ume Wabo. And this is Roxanne Smithers with Smithers and Ume Wabo. Thank you for coming to our contract bank and have a good day.